Good morning, Mr. Pretorius.
Morning, Chair.
Good morning, everybody. I thought I would do without a jersey this morning because I thought it's beginning to be warm. But I remembered that this venue is very cold, so I put it on. So I see you also don't seem to have a jersey on. But you might not feel the cold here the way I do. Yes, are we ready?
Yes, Chair. The evidence to be led this week, or for most of this week, Chair, involves the Free State and a particular project that took place in the Free State, the Asbestos project it's come to be known as. Evidence was led by Mr. Dekwana last year in relation to the conduct of that project. And since then, there has been an extensive investigation on the part of the Commission. And the fruits of that investigation are contained in the bundles now before you, Chair. There are a number of bundles that you have.
Just 1 second, Mr. Pretorius. The lighting could be better than it is, I think. I can obviously see you, Mr. Pretorius, but it's rather dark. So I think the technical people will do what needs to be done. Yes.
Okay, we'll look at that, Chair. A number of bundles before you. I trust that 2 years down the line, we've got the numbering and marking of the bundles.
I'm sorry
ready.
again, Mr. Pretorius. It may be, I don't know if it's that light that's behind you. I don't know whether they normally put it there. And it's this. Yeah, okay, I'm sorry, Mr. Pretorius. Please continue.
In any event, Chair, you have a number of bundles before you which contain both the...
I'm sorry. I'm trying to get them to help me with the lighting.
All right, I'll wait till all that is in order, Chair.
But if I'm wrong about thinking it's normally somewhere there, then maybe I just misunderstand what. Yeah, that's much better. Yes. You may continue, Mr. Pretorius.
Thank you, Chair. The bundles in front of you contain the statements or records of interviews with a number of witnesses that have been the subject of investigation, some of whom you will hear from this week. They also contain the report of the present public protector, who made several findings in relation to the project. There are court papers. I'll refer to those in the course of an opening. There are transcripts of the interviews which may become relevant in questioning. There are certain additional documents. But what we have done, because this investigation involves a range of issues, both broad and some of fine detail, the investigation team has, with the assistance of the legal team, prepared a comprehensive investigator's report in which all the fruits of the investigation have been put and analyzed, so that you have in Exhibit TT18, which is in bundles 8, 9, and 10, a complete record of the investigations and an analysis of the interviews of witnesses. That investigation report has been signed by the investigators, and will be referred to in the end. But it does, at the end of the day, comprise an analysis of both documentation produced during the course of investigations, as well as the transcripts and statements relating to individual witnesses, and it's a comprehensive document. The witnesses for today, Chair, are two. Firstly, a Mr. Roets, who's an expert in relation to asbestos. The reason he has been called is that this is more than an issue of procurement and state expenditure, as well as the distribution of the benefits of state expenditure. It is also an issue as to whether the Free State provincial government has carried out its duties, constitutional duties in fact, in relation to the preservation of health and welfare of its inhabitants, particularly in relation to the prevalence of asbestos in low-cost housing. And that is another aspect of the evidence that you will hear this week. In order to assist, Chair, in presenting a comprehensive record of what actually occurred in relation to the asbestos project, I have taken the trouble to prepare a rather lengthy opening, which will record the story from beginning to end, so that when one gets to aspects of the evidence in due course, it will all fit in to an overall picture and be understood by the Commission and by the public, hopefully, in its proper context. So if I may just address you in regard to that, Chair. The evidence in relation to the substance asbestos will be given by the expert. The substance asbestos in its various forms was in the past, particularly pre-1994, Chair, because of its various qualities, used extensively in housing and industry and elsewhere, but particularly in low-cost housing. And what is so sad about this series of events, it's still there. It's a risk to life, it's highly dangerous, causes a number of serious health conditions, and commendably, at least initially, the present executive took a number of decisions to eradicate asbestos. What happened, however, is that hundreds of millions of rands have been spent on this project, but the asbestos is still there. People are still exposed to the danger of asbestos, with few minor exceptions, but they don't affect that principle. That evidence will be given by the expert. Then, Chair, a number of persons have been involved in this project, and it is well to name them so that their role can be understood when reference is made to them in due course. Mr. Dekwana, a former member of the Executive Council and MEC in various portfolios in the Free State Government, has already given his evidence. That evidence has been contested by, amongst others, witnesses who will come forward this week. Mr. Mokesi is the head of department, Free State Department of Human Settlements. It's that department under the rubric of which this project was carried out. Mr. Matlakala, who agreed to give evidence today and will address you in relation to his evidence in due course, is the head of procurement, Free State Department of Human Settlements. Mr. Makepe is the chief engineer in the project management unit, the PMU, of the Free State Department of Human Settlements. He did some verification, the extent and quality of which will be addressed in evidence. There is a Mr. Ignatius Mpambani, often referred to as Ego. He was a member of the joint venture which obtained the contract through the procurement processes, which will be the subject of extensive evidence. He was unfortunately recently murdered and is therefore not available to assist the Commission, obviously. Then there is a Mr. Sodi, who is the CEO of an entity called Blackhead Consulting Pty Limited. He was the other member of the joint venture. In evidence, Chair, you will hear reference to Mr. Mpambani or Mr. Sodi, but it is always in their capacity, mostly in their capacity as members of the entities which form part of the joint venture, which is at the center of the evidence. There is a Mr. Sedni Khabdebe. He's the director of a subcontractor. A Mr. Manyeki, a director of a subcontractor to the subcontractor. And those details are informative. There is a Ms. Diedrichs, who's not going to be called this week. She is the former acting head of department, Gauteng Department of Human Settlements, and the involvement of Mr. Sodi and Blackhead Consulting in the Gauteng project is relevant for issues which will become clearer later. Mr. Tabani Zulu will appear this week. He was the Director General at the National Department of Housing. He's now Director General at the Department of Energy. Mr. Magashule, former Premier of the Free State. Ms. Cholota, who has given evidence. Ms. Moraki, who has also given evidence, who worked in the office of the Premier. Mr. Martin Zwane, another subcontractor, but subcontractor to the joint venture. Mr. Matau, an engineer who was appointed to work on the asbestos audit, and Mr. Jimmy Tau, a beneficiary of monies emanating from Blackhead Consulting. All those persons feature in the story that's about to be told this week. The story begins, Chair, in Gauteng. In Gauteng, a panel of service providers was appointed. There were two panels that were appointed ultimately. The first panel was a general panel to do work of a general nature in the area of housing. The second panel, a much smaller panel, was appointed to do work on the eradication of asbestos. I may say at this stage that you will hear of various phases of asbestos eradication. The contracts one is dealing with here are merely for the assessment of the prevalence and existence of asbestos in low-cost housing. The idea was to identify the extent of asbestos in low-cost housing to meet the needs, constitutional rights, in fact, of people who couldn't afford housing of their own and were, as it were, stuck with housing containing asbestos and could do nothing about it. There is no evidence of any competitive bidding that occurred in relation to the appointment of either panel. That is important because of the procurement processes which followed. But we know that a panel of 8 contractors was appointed to do an asbestos audit in Gauteng, and they did so on the basis of instructions to perform work within the rubric of the panel appointment. The price that Blackhead charged for the assessment, not the eradication, the assessment of the existence of asbestos was 650 rand per unit. And that documentation is contained in the bundle. That whole procurement was declared at a stage irregular by the Auditor General. Importantly, Chair, there was no individual contract in existence between Blackhead and the Gauteng department relevant to this evidence. At the time, that contract was, and I use the word loosely, transferred to the Free State. Nor is there any evidence that a fair tender process preceded the conclusion of any contractual arrangement between Blackhead and the Department of Human Settlements in Gauteng. You will hear the detail, or more detail, of the precise timelines involved. But at a stage, a procurement process was entered into, which I will describe in a moment, which allowed Blackhead, and I stress Blackhead for the moment, and allowed the Free State Department of Human Settlements to participate in the contract in Gauteng. That process was entirely flawed for a number of reasons, and we'll deal with it in detail in a moment. The other aspect of the Gauteng evidence, Chair, is that the evidence of Mr. Sodi shows that the profits were massive. Sodi is clear that he was paid for his investigation, assessment of the prevalence of Gauteng in the areas that he was asked to do. He was paid almost 230 million, or in the region of 230 million rand, and his profit on his own version was in the region of 100 million. He says that all the others involved in the same project but in other areas in Gauteng, their profits ranged between 50 and 60%. That evidence you will hear in due course. But I stress two things. No contract was in existence at the time the contract in Free State was signed. Secondly, the Gauteng contracts don't appear to have involved any competitive bidding whatsoever. And this all as a background to the fact that the contracts in the Free State didn't involve any competitive bidding whatsoever. And that casts a shadow over the Free State procurement processes. There are two aspects to procurement in the Free State. The one is what is called the participation process. The other is the unsolicited bid process. Both were entirely flawed. Treasury Regulation 16 capital A 6.6 is the one relevant to the participation process. It reads, Chair, the accounting officer or accounting authority may, on behalf of the department, constitutional institution or public entity, for the purposes of this matter, the accounting officer of the department may participate in any contract arranged by means of a competitive bidding process by any other organ of state, subject to the written approval of such organ of state and the relevant contractors. The idea behind that provision is that if there is a competitive bidding process, say in one department, that produces a contract binding on those two parties. The second organ of state or second department may participate in that contract. It's not anything that allows the formation of a new contractual relation. There must be an existing contract entered into by means of a competitive bidding process, and the participation is in that contract, not a new contract. There will be detailed submissions to you in that regard.
Just to make sure I follow, if the contract in which Free State Department may participate is a contract relating to the Gauteng province government, does the Treasury or does the regulation or instruction mean that it's simply an expansion of the scope of the Gauteng contract to include Free State, but otherwise everything else is the same contract? At a practical level, if one says it's not creating a new contract, how would that work practically?
Yes, we've consulted with a person in Treasury who may well have to come and explain it to you, but we have his views recorded. Those will either be presented in the form of submissions, but insofar as a practice has developed under the rubric of the provisions and the regulations, it may be necessary for him to explain those things in more detail. But for the present, to answer your question, Chair, where there is a contract for sale of goods, for example, Free State, Gauteng would enter into a contract with a supplier for 100 widgets. Only 80 would be provided, and so another entity could engage or participate in that contract to obtain the other 20. That's the principle with goods. Of course, with services, it's different, because services inevitably are, as you would point out, and as underlies your question, Chair, services are inevitably confined within a particular personal relationship or relationship between contractor and entity. So we understand that it is permissible for the services to be extended. The practice is that it should be done by way of an addendum to the original contract. But other than that, all the terms and conditions must be the same. The parties must be the same. The services must be the same. The price must be the same. There can be no adjustment to suit particular conditions, because then it's a new contract. And then the competitive bidding, which was the origin of the first contract, becomes a nullity, becomes superfluous, because there's a new set of terms and conditions, which happened here.
So would it, as you understand it, would it amount to saying, in the context of Free State and Gauteng, in effect, would it amount to Gauteng saying to the party with whom it has a contract, you go to the Free State and provide the same services, and then that's what happens. The addendum would effectively say that.
Yes. The steps would be the following, Chair. There would be a competitive bidding process in Gauteng.
Yeah.
It would produce a contract with a party on certain terms and conditions, including price. The nature of the service is what is important here.
Yeah.
The price is what is important, and the party that was party to that Gauteng contract is also important. What happens then is, with the permission of the head of department in the receiving entity, and the contractor agree that Gauteng contract stands, it's still in existence. But the Free State may participate in that existing contract.
Yeah, not a new contract.
Not a new contract.
Yeah.
Although the services inevitably will be in a different region.
Yes.
And that would require an addendum to the existing contract. So it's an existing contract entered into by means of a fair bidding process, competitive bidding process, with a particular party under certain terms and conditions of contract. None of those requirements were met in this case, but I'll deal with it in detail.
Okay.
The first point, Chair, is that different parties were involved. In Gauteng, it was Blackhead Consulting Pty Limited. Sometimes it was described by another name, but for present purposes we can accept Blackhead Consulting Pty Limited in Gauteng. In the Free State, it was a different party. It was a joint venture between Blackhead Consulting and Diamond Hill Investment. That was really the entity through which Mr. Mpambani operated. Now, one may say that this is really a minor distinction. What is the difference between Blackhead and a joint venture? But the significance is this, Chair. Mr. Mpambani, according to Mr. Sodi, had no knowledge or experience or capacity to deal with asbestos eradication. He contributed nothing to the contract at all, save to unlock the opportunity in the Free State through his contacts with officials in the Free State. For that, he got 50% of the income. Now, anyone who fairly and responsibly examined this contract before signing it in the Free State would say, well, why must we pay double the price charged by Blackhead for doing all the work? Well, they didn't do all the work, and that's part of the developing story, Chair, but let me not distract you. Why would we pay double the price charged by Blackhead, which is the entity with the experience and capacity, supposedly, to a joint venture? This doesn't make sense in ordinary and legitimate circumstances. So the participation contract going to a joint venture is significant, and it's more than just a heading or a title of a party. The second thing that should be noted is that it's apparent from the correspondence between the officials who enabled this participation process, both on the Gauteng side and the Free State side, that what was transferred was not a particular contract with Blackhead. What was transferred was the panel, participation in the panel. The panel arrangement was transferred. So in other words, either 50 or 60 in the general panel arrangement, or 8 contractors in the asbestos removal arrangement, that was transferred. But what resulted on the Gauteng side and what was accepted was one contract with one entity, the joint venture. So there's a huge question mark. In fact, it's not even a question mark. There's a huge problem and irregularity in relation to what was transferred from the one side and what emerged on the other side. A panel arrangement on the one side, a particular contract with a particular party on the other. And that correspondence will be dealt with in evidence to show that. But the other point is that the Gauteng contract had expired. Both the panel contract and the original the original panel contract, the narrower panel contract, particular particularly aimed at the eradication of asbestos, and any arrangements that might have existed with Blackhead. They'd all expired. So at the time of the participation, there was nothing in existence to participate in, and new contractual arrangements had to be made on the Free State side. Of course, the joint venture on the Free State side, not Blackhead, and I've explained that, Chair, was appointed not as a participant in a panel arrangement, which the officials purported to allow participation in, but was appointed in its own right with its own price. It was now no longer 650 Rand per unit, but 850 Rand per unit. Different price, different terms of conditions, different parties, no contract on the other side. On every count, it must have been, and we will submit in due course, apparent to the officials who were dealing with this process that there was no lawful justification on the basis of participation and the relevant Treasury regulation for the contract in the Free State. What is important is that the participation process allowed the contractual arrangements to be entered into the Free State without any competitive bidding process. The fact that there was no competitive bidding process and then it wasn't transparent, just two of the requirements of the Constitution, Section 217, means that one could enter into a contract at an entirely inflated price. And it seems not unreasonable, Chair, to draw the conclusion at the end of the evidence, which we will submit to you, that the participation process was really quite a clumsy sham to cloak the Free State Department contract with the joint venture with a veneer of legality, unsuccessfully on examination. So in the event, Chair, what happened in the Free State was an entirely new contract arrangement was entered into with a new party on new terms and conditions, including a higher price, without any transparent competitive bidding process having been entered into. And as a result, the third requirement of Section 217, an entirely non-cost-effective arrangement, was entered into. Now, several state officials participated in that process, Chair. The initials of some of them appear in a document presented to the Commission by Mr. Dekwana entitled Cost of Business. And against initials of people whose initials happen to coincide for the moment, Chair, because we've got to go through the evidential process, with officials involved in this participation process, there are sums of money allegedly dispersed in whole or in part to them. That cost of business schedule has been the subject matter of extensive investigation, and the evidence in relation to that will be presented to you in due course, but I will deal with it in more detail later. And then it's perhaps important to emphasize, because we're coming now to the participation of Mr. Mpambani in this whole venture and project, to emphasize that the appointment of the JV entitling Mr. Mpambani and his entity in the joint venture to 50% of the income of the project, effectively doubling its price to 255 million Rand. All he had no expertise, no capacity, no ability to contribute to the work, except he had to unlock the opportunity through engagement with Free State officials. For that, he became entitled to half of 255 million Rand. But that was the value of his engagement, and I'll come to more of that in due course. Then there was another process. A cynic would say a plan B here. The origins of the contract that was ultimately entered into arguably have a different procurement source. One equally deficient in law, we might add, and we'll make those submissions in due course. And it happened as follows. And these were the facts are significant. On his own admission, Mr. Sodi and his entity, Blackhead, made significant profits in Gauteng, 100 million rand. And he therefore saw that there was a similar opportunity in the Free State. So Mr. Sodi and Mr. Mpambani meet at a function in Belcom, and they meet again later to discuss a possible asbestos project in the Free State. The initiative, therefore, for this project doesn't come from any entity in the Free State which is anxious to protect the lives and health of its inhabitants. Rather, it comes from Mr. Sodi and Mr. Mpambani. By all accounts, it appears that Mr. Mpambani was well connected and influential politically in the Free State. It's apparent from the evidence of Mr. Sodi, and this will be put to him when he comes on Friday, that Mr. Mpambani had no knowledge or experience of asbestos removal. In Mr. Sodi's own words, in the words of the partner, his task was to, quote, unlock the opportunity. For this, he would get a 50% share in the income of the newly to be formed venture, what we refer to as the joint venture. Mr. Sodi is explicit. It was his job to engage with the officials that would allow this project to continue in order to ensure that the contract was granted to the joint venture.
I just wonder, I know I'm interrupting you, I just wonder what unlocking of opportunities there should be in the public service with government work.
Well, exactly. Okay, we have a system in place. It's clear. Where there is a need for work to be done,
yes,
there is an opportunity for all to participate. Now, the opportunity here was not for a contract to be given generally to contractors out there for a fair bidding process. The opportunity was for the joint venture to do the work. That was the opportunity that had to be unlocked. What had to be achieved through engagement with the officials was a particular contract with a particular party. For that, the idea was, at least in the beginning, that Mr. Mpambani and his entity would get 127 million rand for unlocking. That's all. That's all he could do, but he could do it, and that's all he did do, and he did do.
Well, I guess there may be an argument that says it's not very different from a commission, not for doing work, but for unlocking, because you don't do any work at all. You speak to the relevant people, and then a contract gets achieved. And then I guess you say to Blackhead, I am responsible for getting this. You will do the work. Maybe you would not have got the work without me.
Yes, one can label it in various ways. But what happens here is
Of facilitation fee.
Mr. Or cost of business is the...
Cost of business.
Yes. Or business development. We've heard that term throughout.
Business development fees.
But if one takes away the label and looks at what happened, two persons with an interest in state contract get together. The one says, I will do the work, or I will ensure that the work is done, and there's more to come on that score. For that, I'll get my 127 million rand. All you do is you go and speak to certain officials to make sure I get the contract. But please make sure I get the contract. I don't want any nonsense with competition and open bidding, because I'm going to charge a lot of money. But that's all you have to do, go and speak. And for that, you can have 125 million rand or 127 million rand commission. It's the facts that reveal the task of Mr. Mpambani was not simply to do what was lawful and proper by the way of business development. It was to ensure that the procurement process was so arranged, and one could go so far as to say manipulated, to ensure that the contract at that price was obtained without a competitive bidding process by the joint venture.
And of course, it seems quite logical that in that kind of scenario, the party that has the ability, the skills, expertise to do the work wouldn't do this work, wouldn't accept this contract if what it will get in terms of the fee or the price would be lower than what it would be entitled to generally for doing that kind of work and that amount of work. Therefore, if what that party got if one looks at what that party got, one is likely to say that can't be lower or much lower than what it would normally be entitled to. Therefore, to the extent that the price for the whole job included the other party's 50%, then the whole price must be highly inflated in order to make sure that there is this 50% for the other party.
Precisely.
Because if I normally do this job for 1,000 rand, I'm not going to agree to do this job for 500 rand just because you must get the 50%.
Correct.
So the price will have to be inflated to 2,000 rand or whatever. So I will still get at least what I would normally get, if not more. So, but then you get your own. But in the process, the one who pays pays an exorbitant amount.
Yeah. Chair, that's exactly right. That analysis is exactly what happened here. What is interesting is the corollary to that. A person investigating the value for money in that contract before signing on behalf of the department would look at it and say, but you're doing all the work for 1,000 rand. Why must we pay taxpayers' money for business development and unlocking opportunities to your JV partner? It doesn't make sense. And so that is also instructive. But of course, the persons examining the contract arguably were the persons unlocked. But we'll come to that during the course of the week. Subsequent to the engagement between Messrs. Sodi and Mpambani, Chair, they did make an approach for Mr. Mpambani for his 127 million rand commission for business development fee. went to see the HOD of Human Settlements in the Free State, and they said, give us a proposal. Right? An unsolicited proposal was prepared and presented, and it resulted in a service level agreement being entered into. Now, this service level agreement, as you will learn in due course, was deficient in a number of respects. It didn't contain any information as to the overall price, just a price per unit. So there was no mention of 255 million rand in the service. It had a different price per unit to what happened in Gauteng. It had a number of provisions regarding payment and what had to be done to earn payment, which apparently were ignored in the execution of the contract. But what is interesting about this, there was no budget for this project. One must recall this initiative didn't come from the Free State Department. It came from Messrs. Sodi and Mpambani. They went and said, look, let's do this work and enter into an SLA. So the money had to be found somewhere. So what the SLA, the service level agreement, said, quite oddly, is that the joint venture would see to the funding of the project. Now that's an extraordinary clause.
It's very strange. I saw that and I wondered what it meant.
Well, clearly it can't have meant, Chair, that the joint venture would pay for the project itself. It wasn't, as will be apparent and has been apparent in the Gauteng in the business of charitable work. And clearly it wasn't its intention to go out and, as it were, crowdfund the project by way of public donation. What it meant, clearly in the context, Chair, was that the joint venture, and in particular Mr. Mpambani, would continue to complete the unlocking of the opportunity process by ensuring that sufficient budgetary arrangements were made to allow the Free State to pay for the project. In other words, there had to be some, environment is the word that is used, or any other arrangement, a reallocation of priorities, or another arrangement to make sure that the budgetary provisions were changed or altered in such a way as to allow the Free State to fund the project. So all this unlocking of the opportunity was happening without a budget provision. What happened was that matters were so arranged that the budget became available. And that is where Mr. Zulu will testify. What ultimately happened, of course, is that the funding came via the national department from another province. And that was done after the approach, not before the approach. But once again, importantly, for the conclusion of the service level agreement, no competitive bidding process was entered in. Now, where one has an unsolicited bid process, Chair, there is a requirement in order to safeguard the fiscus that all the arrangements inherent in the unsolicited bid process must be published by a request for quotation. So that's where transparency comes in, so that there is publication and any bidder, any organization can say, the joint venture is going to do this work for 255 million rand. I can do it for 50 million rand. I want to put in a competing bid. There was no transparency, no request for quotations was issued in this case. It was entirely secretive. So there was no ability for the department to test the market, assuming, as we must when we start, Chair, that all the officials in the Free State were acting in good faith and properly. They would receive this proposal, they would look at it, they would see that they were paying half of 255 million rand for how a commission, business development, whatever you want to call it, cynically, or in Mr. Sodi's own words, unlocking the opportunity and engaging the officials to facilitate the project. They would say, but why are we paying for that? That's your cost. That must come out of your amount. But they would say, look, we're not experts in this. Let's test the market. Let's see whether your price can stand open and fair competition as required by the Constitution. Transparent, fair, equitable, cost-effective, says Section 217 of the Constitution. They didn't do that. No request for qualification was entered into at all. And that should have been done in terms of Treasury regulations and practice notes. Nor was there any due diligence exercise conducted in respect of the joint venture. Had that been done, the contract would have been examined, and it would have been discovered that at least half the joint venture at that stage had no qualifications to do any of the work. But in any event, if one goes, that's the factual position. If one goes to the law, none or very few of the requirements for the consideration of an unsolicited bid were met. In order for an unsolicited proposal that doesn't go through an open bidding and tender process to even be considered, certain prerequisites are laid down by Treasury. There must have been a comprehensive and relevant project feasibility study to establish a clear case. The product or service must involve an innovative design. No innovative design here. You had 8 contractors in the Free State, and the expert will tell you that there are many that can do what was done. It must involve an innovative approach to project development and management. No evidence of that. And it must present a new and cost-effective method of service delivery. Clearly, as the facts will show here, none of those provisions were here. And so it's difficult not to draw the conclusion in this case that insofar as this contract was sought to be justified by reference to the unsolicited bid process, this was, again, merely a sham to cloak an entirely improper and irregular procurement process. Chair, let me deal briefly with the budget issue. I've stated that there was no provision in the provincial budget at the time the contract was entered into for the 255 million cost of the project. To cater for the non-existence in the budget of a budgetary provision for this project, for this 255 million rand, that clause that I referred to earlier was put into the contract, that the costs, the joint venture takes full responsibility for dealing with the costs of the project. So you have here a department entering into a contract with a contractor who says, don't worry, department, I'll see to the costs. And that had to be achieved. And that was achieved.
When I was looking at that in the agreement, I wondered to what extent, I mean, the impression I got, I don't know about you when I saw it, it was like the department wasn't going to have to pay anything. That's what, and that, of course, that sounds strange, but that's my first impression of what it meant. But you say that it was understood by those concerned that the joint venture would see what it needed to do to make sure that the department had a budget.
There can be no other explanation for those facts, because the service level agreement is now entered into. The joint venture doesn't say, don't worry about the costs, we're going to pay everything. It says, we are going to charge 850 rand per unit. But we will find the money to pay us. Not that we will do it for free, or that we will raise the money, but not charge. And the only reasonable explanation for that clause was that the money didn't exist in the budget, and budgetary provision had to be made. Because that's what happened. Because what happened then, Chair, is that Mr. Mkhize and Mr. Zulu were engaged, and a process was then carried out whereby the absence of a budgetary provision was cured by the rectification of the budgetary provisions to allow payment of 255 million. So there can be little doubt that what the parties meant when they said you will see to the provision of the funds was that you would unlock any obstacle that existed in terms of the budget. It was at all times contemplated that the joint venture would receive income for the project. And it said so in the SLA. It said in the SLA, you will be paid. And you will be paid on presentation of an invoice. And you will be paid 850 rand per unit. But where the funds come from, it's your problem. And that problem on the probabilities can only have been finding the money from official sources, which was actually then carried out. So what happened gives an indication, looking back on the contract, as what that contract meant. What had to be done, of course, was that the provincial department then had to present a revised business plan. So Mr. Mkhize says, we need money in the budget, and he speaks to the Director General National, Mr. Zulu, and they then, and this is all on the correspondence, we've got it in the investigator's report. Mr. Zulu says, but you must give me a new budget plan and a new provincial business plan, because the province has a business plan for the expenditure of its money. It now needs a new business plan to justify the introduction of 255 million rand for the asbestos project. There was no intention to do it originally in the budget. Now there is for a particular project. So the business plan must reflect that project. So a business plan was prepared and presented to National, and that unlocked the funds. But what is important here, in fairness to Mr. Zulu, a gross misrepresentation was made to him in the business plan. You will recall, Chair, that there were two phases to the asbestos eradication project. First, the inspection of houses and the assessment to show that in the Free State there are 36,000 houses approximately that contain asbestos that must be removed. That is the project that was the subject of the charge of 255 million rand. It was entirely an audit and assessment project. Once that has been done, of course, all that information, and in this case the expert will tell you it was insufficient information, but all that information is used by a certified asbestos remover. The joint venture Blackhead wasn't certified, to take that asbestos out of the house, replace the roof if it's an asbestos roof, take it to an official dumping site and dispose of it in a manner which doesn't cause a problem to the health of the community. That's the eradication phase. So you have the assessment phase and the eradication phase. What Mr. Zulu was told in the revised business plan is that the rate will be to conduct door-to-door assessment at 850 rand per house excluding VAT. All asbestos will be removed and disposed of as laid out in the Occupational Health and Safety Act regulation and regulations of 1993. And that is followed by the following. The above unit rate, 850 Rand in the revised business plan, includes the following: submitting a works plan, notifying the Department of Labour of our intention to remove and dispose contamination, rubble, asbestos, contract for the services of an approved inspection authority for the purposes of air monitoring, supply experienced medically fit staff and supervision for the purposes of removal, the supply of all safety equipment and relevant PPE, cordon off the area to be stripped and replace relevant signage. So when you go to the house, you're destroying asbestos. The fibers are then airborne, and you've got to take stringent and statutorily controlled precautions to protect the community within which this activity is taking place. Transport of the asbestos to a registered disposal site, disposal cost of the asbestos, all relevant paperwork pertaining to health and safety legislation. So what Mr. Zulu was told, at the rate of 850 Rand per unit, not only would the assessment take place, but the removal and disposal would take place. A gross misrepresentation. Because neither Mr. Mkezi in the department, nor any representative of the joint venture remotely contemplated the removal and disposal of asbestos as being included in the unit cost of 850. It was complete misrepresentation. If I may just then deal with certain clauses in the service level agreement. The service level agreement is also, as I've said, sparse and confusing as to what work was contracted for. But it appeared that although the price of 850 Rand was for the assessment and audit part of the whole project, it seems that the service level agreement appointed the joint venture to do the removal as well. I'm not going to go through the particular onerous provisions of the SLA which were disregarded in the execution of the contract, but every claim for payment had to be accompanied by a report and had to be accompanied by a detailed verification of the reason why the amounts were particularly charged. It doesn't seem that that was done at all. The project for which the joint venture was appointed was described in the SLA as the appointment of the service provider to assess, audit houses roofed using asbestos material, handling and disposal of asbestos sheets to an approved designated disposal site. Phase 1 and Phase 2, that was the appointment. Quite improper to appoint JV for either, but particularly and especially for the latter task. That requires accreditation, statutory accreditation, and the expert will tell you about that in due course. Chair, what is also important is the lack of attention given to detail. One is not simply buying pen and paper for a stationery department within a government department. One is dealing here with life, the livelihood and the health of inhabitants of dangerous material in houses, life-threatening material in houses. If one looks at the description of the project, it's all about roofs. But the expert will tell you that asbestos in these houses may exist in water pipes, it may exist in fascia boards, it may exist in ceiling boards. It's not enough to look, as happened here, at a desktop image, Google Maps, for example, of houses and say, that's an asbestos house, we better go and look at it, because its roof is made of asbestos. It's entirely superficial and unprofessional approach to the problem. But that will come out in the detail, Chair. As a result of the SLA, an instruction to perform work was issued, which said what amounts making up the 255 million rand would be paid at what stage. And here's another interesting fact, Chair. There was a prepayment of 51 million rand. And you will learn that the cost of the whole project could not have exceeded an amount in the region of 51 million. So upfront, before any work is done, all the costs of the project are seen by way of prepayment. But we'll deal with that in more detail in due course. Then, Chair, subcontracts. The intrigue in relation to this joint venture project doesn't stop there. Because what the joint venture does, it appoints a subcontractor, master trade, to do, subject to a minor qualification, and I stress minor qualification, to do all the work. The JV says to master trade, and master trade will come and talk to you. The JV says to master trade, here's what we have to do. You do it, and we will pay you 54 million rand. All the work, Chair, bar a minor qualification. Now, it's one thing for a contractor to go to a government department and without qualifying or minimizing what happened in this case on the part of the contractors. You have a person in the department who allows this to happen without properly interrogating a competitive bid, arranging things so that there need be no competitive bid, without interrogating the costs in any way, to allow a 255 million rand contract to be done at 55 million. Now, the evidence will be, Chair, that it was done at far less than 54 million. So even that 54 million rand was an inflated price. On the evidence of master trade, the profit made by it there was 19 million. In any event, the SLA, the service level agreement, and the unsolicited proposal, which preceded the SLA, made no mention of the fact that virtually all, in fact all of the work to be done on the project would be done by appointed subcontractors. And at what price? Of course, that wasn't mentioned. The truth is that they did the work, the subcontractors did the work at a fraction of the total cost. In fact, what Master Trade did was it subcontracted once more to another entity, Ori, and Ori did all the work for 21 million rand. But perhaps before I go into the detail, would this be a convenient time?
Yes, okay, let's take the tea adjournment. We adjourn. Yes, continue, Mr. Pretorius.
Thank you, Chair.
So you, before we adjourned, you were making the point that Blackhead or the joint venture subcontracted the work to Master Trade, and Master Trade subcontracted the work to another company.
Yes, Chair.
Yes.
And that latter company did most, if not all, of the work
Yes.
on its version at a fee of 21 million rand, on the version of Master Trade for a consulting fee of 5 million rand, with Master Trade paying the expenses. But, Chair, I will, perhaps it's appropriate to deal with it now. The details of these subcontracting arrangements and the prices attached to these are a matter of intense dispute between all involved. So the joint venture is suing the department for 30 million unpaid. Blackhead is suing the estate of the deceased partner in the joint venture. One subcontractor is suing the main subcontractor. So there is a flurry of litigation between all these parties, each alleging something else. But what is manifest in all this is that there is no legitimate or reasonable comparison between the cost of the work actually done in the region of 50 million rand, probably much less with its built-in profits, and the 255 million rand charge.
Yes.
That is the point for present purposes. The details we have, the various versions we have, they're all in the investigator's report.
Yeah, because the effect of all of this must be that the entity that did all the work, if it could do the work for the price that it charged, it must mean that a reasonable price for the work can't be too much higher than more or less what the entity charged.
Yes. The final subcontractor in the line bid to do the work at 21 million rand, and on its version made a substantial profit.
Yes.
On that score, and has not been paid.
Yeah.
But that detail will come out in the wash, as it were. But what it does show is that the value of competitive bidding, because any one of these entities could have bid in its own right for the contract, if the contract had been properly advertised and properly open to a competitive, transparent bidding process.
And I guess ultimately one of the questions for the relevant government officials is on what basis did they believe that the price that they agreed to pay was reasonable when there were, as a matter of fact, entities who could do the job for far lower in terms of the price.
Well, that's the purpose of a proper bidding process, a transparent bidding process, so that all parties who can do the work and wish to do the work can put in their bids on a fair, competitive, transparent basis and have those fairly and properly assessed. Of course, in order to justify a contract for this work at 255 million rand, one couldn't have a fair competitive bidding process. It had to be avoided at all costs and was successfully avoided in this case.
And of course, if it is shown that the job could have been done at 50 million, 40 million, 20-something million, but the department paid over 200 million, then if that is shown, then there must be a way of getting back from the people who didn't do their job or who decided to conduct themselves in a certain way to the prejudice of the taxpayers, to get as much from them as possible.
Exactly. You will see further on in the narrative that the matter was investigated by the public protector, the current public protector, and a report. I'll summarize the main findings in the report, and is in fact being investigated by law enforcement agencies at the moment.
Okay.
Okay, so to summarize in relation to the subcontractors, the joint venture, or 50% of the joint venture, because the other 50% is busy unlocking opportunity. The 50% of the joint venture arranges for subcontractor 1, Master Trade. Master Trade's quote for all the work, bar a small and not monetarily significant part of the work, 44 million rand. Master Trade then says to Ori, you do the work. I'll keep an eye on you. 21 million. The expenses, according to Ori, for the work and the contract of the second subcontractor approximate 9 million. So these details are important, but it's all relative, because this is a squabble in a confined space, as it were. It's whether it's 5, 21, or 44 million. The truth is that all those figures pale in comparison to the overall price of 255 million rand. And it's not, I think, the task of this commission, Chair, to work out which of the subcontractors in their various disputes is correct. The point is clear in relation to the overall cost to the fiscus of this project. And the expert will tell you a little more about the quality of the product for which 255 million rand was paid, and you will hear in a moment, Chair, about where some of this money was dispersed. Chair, because the expert will deal with some more detail in relation to what was done in relation to this contract, we've already told you that the service level agreement was sparse and unprofessional, quite frankly. But according to the chief engineer of the department, Mr. Makepi, his idea of what would be done, not contained in the service level agreement, was that the houses containing asbestos would be audited. In other words, the number of houses containing asbestos would be audited, and there would be an assessment accompanying that in relation to detail that the expert will explain. Those houses would be labeled or identified with a geo-positioning, GPS identification. There would be some details provided regarding the structural integrity of the houses. Doesn't seem that that was done. In other words, if the house is about to collapse, then the whole house should simply be demolished and rebuilt. And also removing asbestos in a house which is not structurally sound has its own dangers. And all that information would be collated in a report and provided to the project management unit so that they could go take the next step. Now, Chair, the way this is done of course, is that you sit at a desktop computer and you look at aerial maps of the region and you say, that looks like an asbestos roof, that looks like an asbestos roof. You then train people from the community to take a laptop, or not a laptop, a device, to the house and take a photograph of that house. And all that information then is collated and put into a report. Mainly, there would be a picture of the roof taken, because remember the SLA chair talked about roofs of houses, not water pipes or fascia boards or anything like that. And that data is then used to produce reports. Notionally, that data then allows the second phase of the project to take place at a later stage, which the business plan and the SLA appointed master trade to do. But the expert will tell you this has to be done properly, because you're taking out a life-threatening substance, you're exposing fibers, those fibers are carried in the air, people breathe them, and they, quite frankly, die. I've referred to the several disputes between the parties involved, but again, they're disputes within the confines of a limited amount of funds. The established facts show, just to summarize, the provincial government undertakes to pay 255 million rand. Master Trade quotes 44 million rand to do most of that work, bar 10 million rand. The Master Trade's quote of 44 million rand includes a 17 million rand profit. And there are expenses listed differently in the evidence of different witnesses. So, for example, Master Trade said they would spend 3 million rand on data for the digital devices to take the photograph. The expense list in Ori's subcontract is 60,000. So there are all sorts of question marks when one digs into the detail of even the reduced amounts of 44, 21, and the like. So just, if one takes all those versions together, and again, perhaps this is an area of too much detail for present purposes, it's all in the report, in all its detail. Either the second subcontractor, Ori, Mr. Manyeki, does all the work for approximately 21 million rand, involving 9 million rand expenses, so more than 50% profit. Or between them, Master Trade and Ori do the work for 44 million rand less expenses. Or according to Mr. Khadebi of Master Trade, the field work is done by Manyeki as a consultant for 5 million. Whatever version finally wins the day in the courts. There is no question of a gross overcharging contract between the joint venture and the department. Then there's the question of invoices. Once again, it seems that the payment of invoices and the recordal of work done to justify the payment is wholly inadequate and bordering on the improper. Or not bordering, simply improper. It may be, and this requires further investigation, but it may be that the documentation which accompanied the payments of the invoices contained gross misrepresentation. There are documents which show, Chair, when a payment, for example, of 50 or 30 million rand is paid. In a column in the document that asbestos was removed. But before taking that further, it would require an answer. We don't have the answer yet, but there are huge question marks around, firstly, the adequacy of the documentation accompanying payments, and secondly, regarding the representations made in those documents. Ultimately, audit reports were provided. Several reports were provided as a result of the conduct of the work under the contract, the joint venture contract, and these reports are part of the documentation before you, and the expert will examine one of those reports in a lot more detail. Because one can't assume that even though 44 or 21 million rand was done, the work was properly done. The work was done with sufficient care and caution to guard the rights of the people in the communities who are living with asbestos roofs above their heads. But what happens, Chair, is that after the payment of 230 million rand, 25 million rand outstanding, which is the subject of a court case at the moment, the public protector began an investigation and produced a report, the current public protector. And so once that report came out, the head of department, Mr. McKessie, suspended further payments to the joint venture. And that was at the stage where 230 million of the 255 had been paid. In summary, the public protector, having investigated the matter through the Free State office, made the following findings. I'll just deal briefly with the main findings of the public protector. Firstly, a complaint regarding the violation of procurement processes in the awarding of the asbestos contract was substantiated. The public protector found that the participation element, you will recall that was the first device used to avoid the open tender process, was improper. Because, quite simply, there was no existing contract that was participated in, a new contractual arrangement was entered into with different terms and conditions. And what the public protector said was that the participation process requires the same service provider, absent in this case, the same services, not clear in this case, and the same price, certainly not clear, no, not existing. Then, Chair, the public protector also found that insofar as it was sought by anyone to justify the procurement process followed by reference to the unsolicited proposal rubric, that too was also flawed and unlawful, particularly because there was a failure to issue the request for quotation. In other words, to publicize this arrangement so that other parties could enter the fray if they wanted. It was simply described as an abuse of the procurement system. Secondly, the public protector found that the service level agreement was in contravention of the department's own supply chain management policy because it didn't actually reflect what was said in the unsolicited proposal or the appointment. So it was a poor document in all respects and also contravened the department's own supply chain management policy. What happened in the Free State, similar to what happened in Gauteng, is that the Auditor General of the Free State declared the procurement as irregular. Released that report on the 31st of July 2015. And Chair, you have expressed concern about what happens to these reports. What is their effect? Do they result in any concrete action that is required by their content? Well, after the release of the report declaring the procurement irregular, the department still made further payments of 139 million rand to the service. In other words, that report was simply ignored. And severe findings, including findings of willful misconduct and gross negligence on the part of the accounting officer, Mr. McKenzie, were found to have existed by the public protector. And then a further finding, the allegation that the services provided were not cost effective and the department did not receive value for money, that was found to be substantiated. So much seems clear even from the brief survey we have given you of volumes and volumes of documents relating to that issue. What the public protector found on her investigation was that the evidence and documents prove that the project was 100% completed and reports were generated by the Ori Group. That is the second subcontractor, the first subcontractor to Master Trade. First subcontractor, Master Trade, second contractor, Ori. The public protector found that the fee for all that work was 21 million rand. And all that work was done. And what is interesting is not only was the field work done by the subcontractor, the second subcontractor, but also the production of reports was done largely with its participation. We referred earlier, Chair, to a complaint about the advance payment. The finding was that that was irregular as well, but for the reason that the original contract was null and void as being contrary to all the procurement prescripts. But I've already pointed out to you, Chair, that that prepayment of 51 million rand was more than enough to cover the costs of the whole contract. So before any work had started, the contract was paid. And what the public protector has directed the Premier to do as a result of the report is to investigate the accounting officer in terms of Section 84 of the Public Finance Management Act and to report the conduct to the Hawks and the South African Police Services, and those processes are underway. There was also a direction that the Director of Supply Chain Management in the department, Mr. Matlakala, be investigated. We will hear more about him later. We've just received a letter from his legal representative, which will, despite his own agreement to attend, undertaking to attend today, explains why he's not attending, or purports to explain. Then, Chair, to close the circle on the asbestos project, there is the evidence given by Mr. Dekwana in relation to the costs of business schedule. Now, this schedule, Chair, has been investigated at great length. It has been put before Mr. Sodi of the joint venture because it's a document related to the business of the joint venture and emanating from joint venture record. So it has been testified to directly. It records several abnormal business expenses. It records them in a way that is abnormal. And it shows, on the face of it at least, and I stress on the face of it because that's where we are at present, payments to persons or entities from the income received, the 255 or 230 as it turned out million rand. Where the schedule shows what may be termed a legitimate business expense, in other words, a subcontractor expense, the payment to Master Trade, it's recorded to the last cent in that schedule to Master Trade. No initials. Master Trade is recorded there as the subcontractor receiving 44 odd million rand in a precise amount on that schedule. But where it's arguable that some concealment is necessary because it's an abnormal business expense. One sees merely initial. Now, the question is it just coincidental that those initials happen to be the initials of officials in the Free State involved in facilitating that? Or is there some other explanation? There doesn't seem to be another explanation.
I mean, what must be clear is that the author of the spreadsheet meant that, those initials refer to somebody.
Yes.
And they refer to somebody who, according to the author, was to be paid a certain number.
Correct.
And Mr. Sodi, because he's still alive and was the 50% of the joint venture, must be able to tell us who was that was to be paid that amount, because you are part of the joint venture. You ought to know, I would imagine. Yes. And of course, it's quite interesting if the initials seem to be similar to initials of somebody who has a role to play in the whole project.
One will recall at the beginning of the narrative, Chair, Mr. Mpambani undertook to unlock the opportunity to engage the necessary officials to facilitate the grant of the contract of 255 million rand value to the joint venture.
Yes.
The persons involved in that process, initials which are the same as their initials, let me put it that way for the moment rather than saying their initials, here on that schedule as the recipient of money. Mr. Sodi says, look, this is a record of subcontractors. I don't know what these mean. So when a person with initials coinciding with the initials of an official in the Free State, whose participation and cooperation was necessary to unlock the opportunity, appear on the schedule as being entitled to, on the face of it, 10 million rand. 10 million rand goes out of his business. He says, I don't know where 10 million rand of my profits went. But he says, Chair, and in a strange way, this has its own logic to it. He says, Mr. Mpambani prepared this sheet. He did it in my office, on my computer, and I don't know where my profits went. I can't explain where tens of millions of rand of my profit go. I'm happy to accept that what he did was correct. But of course, as far as the initials were concerned, it is correct, I stress, that they went to these officials, monies went to these officials. That was his job. Now was the payback time for having unlocked the opportunity, and he had to organize. But there is correspondence between the parties that the investigators have produced. Email correspondence between Sodi and the deceased, Mr. Mpambani, which stipulates that Mr. Sodi is to see to these payments, and Mr. Mpambani will see to certain other payments, and that evidence will be before you in due course.
And then it becomes difficult, and we'll see, Mr. Sodi maybe will explain, it becomes difficult to accept that between the two of them, Mr. Sodi and Mr. Mpambani, didn't know all, who everybody on the list was.
Yeah. And the fact that those initials coincide with the initials of the officials who participated in the facilitation of the project.
Yeah.
Mr. Sodi entirely.
Yeah.
But, Chair, the payments have been, certain payments from the business have been traced by the investigators, and I'll come to those in a
Yeah.
moment.
Okay.
But whatever, for any business, valued, Mr. Sodi's business, there will be evidence that around 2014, 2015, turned over in excess of R1 billion. It was a very, very successful business, and he was custodian of billions of, or at least more than R1 billion. For that business to record the expenses of a 255 million rand contract in the manner in which it was done is, to say the least, extraordinary. The only logical explanation for this unusual recordal of business expenses by reference to initial is the need to conceal, at least to a certain extent. We must deal with particularly the allegations made by Mr. Dukwana and the response to those allegations by Mr. Zulu. Mr. Zulu said that document is simply a piece of paper to which no credibility at all can be attached. Now, whatever the value of that observation at the time Mr. Dukwana gave evidence, as you are aware, Chair, the investigators have taken the matter much further. And so, in relation to deciding the authenticity of the document, apart from answers to questions given this week, there are certain factors which no doubt you will take into account in assessing its authenticity and its reliability as a source of evidence. And we will make our own submissions to you in this regard. But firstly, that document has been admitted to be a document relating to the business of the joint venture in the asbestos project. It has been shown to and testified to in consultation by Mr. Sodi. He says that that document was prepared on his computer in his office by his erstwhile JV partner, Mr. Mpambani. And what he said was that it reflected largely costs payable to subcontractors. In other words, expenses of the business. I've pointed out that certain expenses, initials, certain expenses which would otherwise appear to be legitimate, full description of the recipient of funds. I've dealt with the issue of the initials, which coincide with the initials of officials, and it was Mpambani's work to secure the cooperation of those officials in facilitating the conclusion of the contract in the manner in which it was done and on the terms in which it was done.
To the extent that Mr. Sodi's version is that the document was prepared by Mr. Mpambani, if the document was a business document in the sense that it was internal, Mr. Sodi may have to explain how it would come about that he doesn't know what certain initials refer to, because Mr. Mpambani, if he is the one who put those initials, would have put those initials so that the two of them knew who the person was, because that person was about to be paid some money from the business, from the joint venture.
I'm just looking for the document itself because the point you make is aptly illustrated on the document itself.
I mean, if I write if I prepare a document meant to communicate something to you, I would use, if I use initials, it must be initials that I think you understand or you know. And of course, if you don't know, you'll ask me when you get the document, what does this mean?
Yes. Well, the first question is, this document obviously reflects the recordal of an intent. The next question is, was that intent carried out? And that's the subject matter of certain evidence and investigations that I will deal with in a moment. But just looking at the document here, TZ, cost of business 10 million rand. TM, cost of business 5 million rand. AM, cost of business 10 million rand. OM, cost of business 1 million rand. MEC, cost of business 2.5 million rand. Then we have a name, Master Trade, right? Not concealed. And then names of others who were involved. And
so not empty.
I'm
Master
sorry?
Trade, not empty.
Not empty at all. Nor the person, SR, in Master Trade. Now, to say, as the person in the joint venture running the business, running this side of the business, remember, Pambani's job is to unlock opportunity, that I don't know where 20 to 30 million rand of my profits is going, is extraordinary, an extraordinary proposition at the least. Exactly your point, that one would assume that those initials would be known, unless there's some very convincing explanation why I, as a 50% member of a joint venture, would allow tens of millions of rand simply to be dispersed to destinations of which I have no knowledge. When, if that was so that he didn't know, at least there was a duty to inquire.
Yeah.
Why this coincidence between the initials of officials and the business that I am responsible for? And the legislation is replete with red flags in that regard. And I'll deal with just one aspect of the governing legislation on corruption later. So, Chair, I've dealt with the document containing the initials which coincide with the initials of officials involved in facilitating the project. The document also contains an accurate record of amounts paid to subcontractors, for example, Master Trade, which we know from other original evidence to be the correct amounts paid to them. So the content of the document is authenticated by reference to other original records. Fourthly, Chair, many of the other payments to persons bearing initials or entities bearing initials have been investigated, and they are dealt with thoroughly in the investigator's report. I'll deal with some in a moment, just by way of example. But what is important is those payments do not relate to work actually done. So, for example, payments to Mr. Tau, or payments involving Mr. Tau and Mr. Tau's entities. And the explanation simply is from Mr. Sodi, who acknowledges that payment, says that, well, that's just something that I do from my monies I pay out. But why these should be recorded as business expenses, of course, is another question, as opposed to simply a gratuitous donation. The payments and the relative circumstances surrounding the payments are summarized in the investigator's report, and if I may deal with one or two, simply to put the full picture of the whole project and its outcome before you by way of this opening there. bear with me a moment. The evidence of Mr. Dukwana was clear that, according to his evidence, the amounts reflected on the cost of business schedule were paid as gratification in relation to the Free State asbestos contract. Now, as was correctly pointed out by you at the time, Chair, that was insufficient evidence to actually implicate a particular person. And thereafter, the investigators were tasked to do their work, which they did, and the results of their work I will deal with in a moment. The allegation, and I stress at this stage an allegation because we have to go through the evidential process, is that TZ would have referred to Mr. Tabani Zulu, who was the former DG of the National Department of Government at that stage. And what is reflected is a payment of 10 million rand. Now, whether that is correct or not, it's merely an allegation at this stage made by Dukwana, to which Mr. Zulu will have full opportunity to respond. But what we do know is that Mr. Zulu was at least involved, if not instrumental, firstly in the participation contract, and secondly in the budgetary process of unlocking funds there. The second initial, TM, is alleged, and I stress again alleged, to be the initials of Mr. Tumotsi Maketsi, also known as Tim, the accounting officer and head of Department Free State Human Settlement. It is alleged that 5 million rand would be payable to him. What we know is that the initials TM appear on the spreadsheet, and we know that he was involved in signing the contract, involved in the participation and the unsolicited part of the contract, the signing of the SLA, payments and the like. He's the accounting officer, and in terms of the Public Finance Management Act, he cannot escape liability. He can delegate, but it's very clear in the legislation that he retains accountability for that. AM, we know that the former Premier's initials were AM, Mr. Magashule, and we know there has been evidence of certain payments made to his office for present purposes. But the legislation is clear that whether you receive an amount of money for yourself or for others, it still qualifies as an offence in terms of the legislation. We'll deal with that in more detail in due. OM, whether coincidentally or otherwise, is the former MEC in the Free State for Human Settlement. MEC, the MEC at the time was a Ms.
You said
Vito.
OM, you didn't mention the name?
No, just MEC.
Oh,
But the MEC at the time also received some benefits. And then Master Trade is there by name, an accurate reflection of the true facts established by facts external to the document. The identity of others has not been uncovered. Martin clearly refers to Martin Zwane, who received monies. There's an invoice for him issued by him for 1.5 million rand, which is reflected in the cost of business schedule. Steve, there's Steve Matau, an engineer who was paid for engineering work done on behalf of the joint venture, an amount of 1.2 million. And then there are others, including JT Jimmy Tao, who also received money, as the investigators found out. And the last name is Diedrichs, which must obviously refer to Margaret Ann Diedrichs, the former acting head of department in the Gauteng Department of Human Settlement. She is the one that signed the participation letter from the Gauteng side, thus facilitating the conclusion of the contract. Mr. Sodi has been interviewed, and he's given much of the evidence necessary to, at the very least, determine the authenticity of the document. It's not a fabricate. It's a real document with real information. The costs reflected there on his version deal principally with subcontracting costs. There's no explanation for how all those persons with all those initials coinciding with officials' initials could have been involved in subcontracting. There's simply a profession of ignorance in that regard, and Chair, you've made your observation about that. He says that document was attached to emails he received from Mr. Mpambani. He says that he acknowledges the receipt of directions from Mr. Mpambani to deal with the persons highlighted in yellow, although he denies making any such payments. He acknowledges that it was prepared on his computer. He says Mr. Mpambani worked in his office. But he would not speculate about the initials, save the concession in relation to JT, Mr. Jimmy Tao. He gives an explanation that he appointed Mr. Jimmy Tao as his, quote, business development manager after the Mr. Tao's retirement from football. But he does acknowledge that Mr. Tao received money generated from the profits in that particular contract. And then there was an upfront payment recorded on that schedule of 4.4 million rand, which was acknowledged as being correct.
Mr. Jimitau is represented by initials as well in the document.
Yes.
So he knows what those initials, who they refer to.
Yes.
Yes, okay.
There was an outflow recorded there in the schedule of approximately an analysis. Sorry, Chair, an analysis of the accounts of Blackhead, the bank accounts, do show payments to various persons involved or represented by their initials, or by initials at least, on that list. There were several financial transactions investigated by the investigators of the Commission in relation to the first initial or person bearing those initials on the schedule, Mr. TZ. There's no evidence at present available to the Commission of a single amount of 10 million rand being paid. Some amounts were traced from the bank accounts of Blackhead, Mr. Sodi, to a motor dealer in Pietermaritzburg. Two transactions are relevant. The first was a payment reflected in the accounts of Blackhead to a TZ. Initials were used. The initials TZ identified that payment. And that payment was recorded on the receiving end of the motor dealer in Pietermaritzburg as Mr. Zulu. So the use of the initials on the side of the payer, the Blackhead Consulting, Mr. Sodi, and the fact that they related to Mr. Tabani Zulu on the receiving end via the motor dealer, correct. In one transaction, the money was used to buy a Maserati for a Mr. Ntuli. Quite where that set of transactions has its origins and why it should be so has not finally been established by the investigators. But what is clear is that TZ, Tabani Zulu, TZ payer, Tabani Zulu recipient, paid for a luxury vehicle out of money, and we know why and where that money should have gone. Won't emphasize the point, it's obvious. There was a second transaction of 600,000 rand, which it is apparent now that it was made by Mr. Sodi to the motor dealer at the time of at the project for an amount of 600,000 rand. It, again, is reflected on the recipient side as reflecting the initials TZ. Now, I may be corrected in relation to all these initials and where they are reflected, but certainly that will be corrected in due course in detail if it is subject to correction. But here the recipient is reflected as TZ, and Mr. Zulu uses it as a deposit for a vehicle, and so much is common cause. Mr. Sodi pays 600,000 rand to a motor dealer. It's used as a deposit for a Range Rover bought by Mr. Zulu. The explanation for that, which you will hear evidence about in due course, is that Mr. Zulu has an involvement or owns a lounge called TZ Lounge, coincidentally, in Pietermaritzburg, which appears to be I don't know what our investigators have been looking at. It appears to be an entertainment establishment of sorts, where on one version or on one explanation, 600,000 rand reflected the amount of the tab run up by Mr. Sodi at the lounge. On Mr. Zulu's version, a more, well, I'm not sure whether it's more understandable explanation is that it was monies owed by Mr. Sodi for goods and services related to the business of the lounge in Pietermaritzburg. Well, let's hear about that in due course, in all its detail. But on the face of it, 600,000 rand is quite a large bill to run up at an entertainment venue. Then TM, there's evidence of monies emanating from Mr. Sodi or Blackhead being paid in the interests of Mr. Mackenzie for the purchase of a property. So an amount of 650,000 rand is paid via a trust to attorneys, which is used to buy a property in which, according to the investigators, it is apparent that Mr. Mkhwezi lives. But the explanation of Mr. Mkhwezi is no, this was a joint business venture. He and Mr. Sodi became friends, and they decided to invest in a property, and there's an agreement which shows how the income from rentals is to be divided and what's to happen in the property in due course. Now, whether this is all genuine or not can be investigated and dealt with in question. But what is significant here is that a person involved in the grant of a tender of 255 million rand, the accounting officer should not be in business with the recipient, because it allows for all sorts of benefits like this to be granted. And certainly this is a benefit. The fact that you have now gained a partner to help you buy a house in which you live for however long, whatever its nature as a joint venture is, does not allow you to escape the provisions of the law in this regard. But quite apart from that, Chair, and as a matter of any recommendations that you may have in procurement, it should be absolutely forbidden that there should be any private contractual arrangements between those on either side of a procurement arrangement. Be that as it may, that is there. And there are others too, Chair, that involve the payment of fees from this money at the request of the Premier of the time, Mr. Matlakala. Now, the legislation is again quite clear that whether you receive a benefit or a gratification yourself or on behalf of others, students studying, it falls foul of the legislation, and no doubt the law enforcement agencies will pay close attention to that in due course. That evidence has been traversed already, but its implications in terms of the legislation may need further clarification before you. Chair, I'm not going to go further in the examples. There are others. They are the subject matter of detailed research. They are all contained fully and in all their detail with supporting documentation and explanation and an analysis of the relevant evidence in relation thereto. Suffice to say that the document appears not only on the face of it, but in relation to all the accompanying evidence to be a genuine document reflecting actual transactions or partial transactions. The evidence shows that people on that, or initials on that, coincide with the initials of officials who received gratification or income or benefits from the monies arising from the contract. And importantly, those persons, to a large extent, were persons involved in the procurement process in facilitating a bid entirely overpriced, massively overpriced, extortionately overpriced, in fact, without any compliance, as found firmly by the public protector, with the procurement prescript. And the evidence in that regard is clear. So the whole story goes full circle, Chair, and it is illustrative not because it is unique or unprecedented, but it shows a pattern. It shows a pattern of the ability to identify a money-making opportunity using funds of the fiscus to that purpose, an abuse of procurement processes, engagement with officials to facilitate the abuse of the procurement processes, the production of work which the expert will tell you simply not warranted even by the lesser amounts that were charged, the pocketing of huge amounts of fiscus meant, Chair, for the livelihood of poorer members of the community, but end up buying Maseratis. It's a very sorry tale, to say the least. But the full circle is there, from the manipulation of procurement right through to the production of benefits, and in between an entirely cost-ineffective and, quite frankly, criminal project. That's by way of opening, sir.
Thank you.
Chair, the witness who has been set down, 2 witnesses were called for today, and Mr. Matlakala, who agreed to come today, but we have learnt recently through his appointed lawyers that he claims he has reason not to appear this week. He was not summoned, but he was here, or to be here by his own agreement. We will deal with that after the long adjournment. I just need to update myself on the correspondence received this morning. And then the expert, who will take up some time now and this afternoon. I don't know whether, Chair, you wish to take an early adjournment or whether we should use the half-hour and adjourn as normal between 1 and 2.
What's your estimate of how long the expert might take?
At least an hour and a half.
Yeah. Well, maybe we should start with him. Sure. We have about 25 minutes, 30 minutes, and then we take lunch, and then after that, yeah.
If we may, Chair.
Okay.
Thank you.
What happened to the lamp that was supposed to be next to the witness? I say it's not there. You would not know anything about it, Mr. Pretorius, but those who know what I'm talking about. It's supposed to be next to the witness so that if they have to read anything, they can do that. So if it's going to be disruptive to take it now, then during the lunch adjournment, it should be placed next to the witness, if this is the one, so that if the witness has to read anything, they don't struggle with seeing the writing.
In the bundle Free State 1 is Exhibit TT1.
Would it be convenient? I know if we say Free State 1, we will know which bundle we are talking about. But do you have any objection if we call it bundle FS1?
I think I could accept that.
Let's make all of them bundle FS1, 2, and so on.
Yes, we'll do that. We'll replace this.
Yes, no, that's fine, yeah. Just so that, if it's Free State 1 without bundle, one doesn't know whether Free State 1 means something else different from bundle.
Sure.
Yeah, so bundle FS1.
So in bundle FS1, for the record, Exhibit TT1 is the statement of Mr. Jacobus Roets.
Yes. And you asked that statement, that affidavit be admitted as and marked exhibit
TT1. Chair, at the moment, and I think this has something to do with the lockdown measures,
Oh, yes, I see it's not commissioned.
it is signed,
Yeah.
but not commissioned. I must just check that.
Yes.
You bear with me. Yes, Chair, the intention is that it will be attested to, but of course the witness can confirm that on oath now.
Yes.
The document,
Okay. Well, I must just then say the document which appears or starts at page 1 of bundle FS1, which purports to be an affidavit by Mr. Jacobus Roets, is admitted and is to be marked as an exhibit and is to be marked as exhibit TT1.
thank you, Chair. The expert has examined a report around which there will be no dispute. It is a report dated February 2015, emanating from the Asbestos project, and will comment on that. That is not attached here to this. It should have been, but it is not. And it will be referred to in one of the bundles. It's in bundle 8, FS8, at page 270. The witness will be asked to identify it, however,
Okay.
and it
all
is
right.
in front of him.
Okay. Is that the one that should have been an annexure to his affidavit
Yes, Chair.
statement?
Yes.
So, but it appears somewhere else?
Yes, Chair.
Okay, in one of the bundles?
Yes.
Okay.
And there's no quarrel about its authenticity
Yes.
or its identification, and the witness will confirm that.
Okay, so I think to the extent that in his statement or affidavit he refers to that document, maybe one must make a note as to where it is to be found.
Yes, Chair. And
Yeah.
for the record, it is to be found at page 270 of bundle FS8, but it may be that it should be attached
Yeah,
to
maybe-
the final
maybe-
affidavit when it is attested and numbering arranged
Yeah,
accordingly.
it may be attached, maybe the last page of the statement is 23, maybe it could be 23 A, B, C, D,
Yes, Chair,
up to
we
the
can do
end. Yeah, then it's more convenient.
Thank you. So, before we start, Chair, may the witness be sworn?
Yeah, okay. Okay, all right. Please administer the oath of affirmation.
Oath.
Please state your full names for the record.
Jacobus Karel Roets.
Do you have any objection to taking the prescribed oath? Do you consider the oath to be binding on your conscience? Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Help me God.
I don't know, you may be seated. I don't know whether the transcribers would have had the responses from the witness. They did not. They indicate they did not hear the responses. I'm going to ask that you repeat the oath. Please take off your mask so that they can hear when you, Mr. Registrar, keep the 2.5 meters distance. Maybe he thought you were too close, that's why he put on his mask.
Please state your full names for the record.
Jacobus Karel Roets.
Do you have any objection to taking the prescribed oath? Do you consider the oath to be binding on your conscience? Do you swear that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Help me God.
Thank you.
Before addressing Mr. Roets, Chair, if I may just emphasize one aspect which emerges from the narrative as a whole, and particularly from the evidence of Mr. Roets, is that not only are we here dealing with the duty to deal fairly, transparently, and cost-effectively with state funds in procurement processes and in the execution of contracts under the auspices of provincial or national government. But we're also dealing with another issue here. The state, and through the state, the executive has a constitutional duty to provide adequate housing and to safeguard the lives of inhabitants of the various communities in the country. The question arises, and you will hear from the evidence, is whether these duties have been carried out. We know that just from the small survey that we've done in this investigation of hundreds of millions of rand being spent in the manner in which has been alluded to in this case, but the roofs are still there, and the roofs with all their dangers are still there. So whether the constitutional duty of the executive has been carried out is a question that will need to be addressed, and we will address it in submission. Mr. Roets, your occupation?
Occupational hygienist.
Right. And do you belong, or are you a member of an entity which, in terms of which you carry out your work?
Yes, we are accredited by SANAS in terms of ISO 17020, and we approved inspection authority by Department of Employment and Labour.
Right, we'll come to that in a little more detail later. But you have been asked to give an opinion in relation to an asbestos audit conducted in the Free State by the Free State Department of Human Settlements in 2014-2015, is that correct?
That's correct.
What are your
I'm sorry,
qualifications?
don't speak too far from the microphone, Mr. Roets, so that I can hear. Yeah.
Would you tell the Chair, please, of your qualifications and experience?
I'm an occupational hygienist. I have done analytical chemistry, a diploma in analytical chemistry with the TUT, and then also completed a professional diploma in occupational hygiene from the British Institute of Occupational Hygiene.
And do you have any experience in relation to asbestos in particular?
Yes, for the past 30 years, more or less, I've been practicing occupational hygiene. And since the start of my business or career, I've worked for Transnet Chemical Services, where I've started dealing with asbestos because they transported asbestos throughout South Africa. So I started monitoring and assessing and assisting in the eradication and removal of spilled asbestos and clean up of asbestos throughout South Africa.
Right. If you could...
I'm sorry, Mr. Roets. Mr. Pretorius asked you the questions, but you are telling me the stories. So make sure I can see you as you tell the story, because sometimes that's important to understand what you mean.
Yeah.
Okay.
Thanks, Chair.
You may address the Chair as the Chair. Right, just be a little more specific there. We'll come back to it in a moment in more detail. But when you say you were involved in work relating to asbestos, there are various stages of that work. What are those stages?
Yes, Mr. Chair. When we do asbestos work, the first thing is to actually identify if there's a problem, the risk associated with the asbestos and the work that needs to be done. So we will most probably start off with doing an inventory or assessment of asbestos in terms of the regulations that was promulgated. Once that you know where the asbestos is, how much of the asbestos there is, and what is the risk, the potential risk of exposure, then you can go and set up a plan on how to mitigate or put in necessary controls for this asbestos. And if you need to remove the asbestos because it's in a poor state or the risk of exposure is higher, then you need to draft a plan of work and submit it to Department of Employment and Labour for their notice. This plan is normally approved by an approved inspection authority before any work is done. And once this plan has been submitted to the Department of Employment, they will, or the work will commence after about 14 to 30 days. Because of the notice periods that you need to provide. And the work then that follows is done by a registered asbestos contractor that is appointed by the Department of Employment. And this appointment or registration used to be done annually, but nowadays the term or the time is actually set on 3 years. Every 3 years they must reapply for their approval. So these are the guys that will come in, and under their training, they will remove the asbestos in accordance with the approved plan of work in a safe and responsible manner. And the waste will then be transported to a registered hazardous waste site, so it cannot be disposed of in a normal waste or landfill area. And once that it is deposited in that hazardous waste site, they will receive a safe disposal certificate that the waste is properly disposed of and will be managed in time to come.
If I understand you correctly, in order to remove asbestos from a particular site, there are particular nature of that risk. Past, including asbestos.
Assessment of hazardous chemical substitution of the lung, and the illness is called asbestosis in the latest stage of your illness. The fine asbestos, blue asbestos that you get, or crucidolite, can penetrate right through your lung and sit on the chest lining where it can cause mesothelioma. And that is a cancer of your chest lining, which is a fatal illness. Most probably you will die within 1 year after contracting mesothelioma. There is also other illnesses like lung cancer that can be caused, and there's some papers currently that people seem to think, or the people that investigate these things and analyze it seem to think that it can also cause colon cancer if people ingest the asbestos by accident. So these are the illnesses that can be caused.
I understand from your paper that asbestos fibers may be released from asbestos material into the air, and then, as you say, they are ingested into the lungs. Once that happens, is it curable?
Well, as we know, and nowadays you can actually transplant lungs into a person. So it is possible if asbestosis is identified in a person that with the medical knowledge that we have got nowadays, that you can actually cure a person, but you will definitely give him a very hard life, because the symptoms of asbestosis is that the hard calcified areas in the lungs will actually tear away from the soft tissue of your lungs when you breathe, and your lungs can start bleeding. So it is a very bad illness to have, and what you actually die of most of the time is a lack of oxygen, because what happens, you decrease the effective gas exchange area in your lungs. So where you need to pick up oxygen or uptake oxygen in your lungs and give off carbon dioxide from your lungs, that area is getting smaller and smaller because of the calcification of the portions of your lung. And so yes, people still die today of asbestosis and mesothelioma.
If one is exposed to asbestos fiber in the manner you've described, is it life-threatening?
It's life-threatening, definitely.
The prevalence of asbestos, as you've stated, has given rise to concerns on the part of the legislature, and legislation has been passed controlling or presaging the eradication of asbestos. Is that correct?
Chair, yes, that's true.
Would you just tell the Chair about that, because one of the matters that the Chair will look at is whether there has, in this case, been compliance with that legislation.
Chair, yes, we have had asbestos regulations since 1983, 87, 89, and then it was changed again in 2001 and 2002. There was a little bit of errata on a regulation that they changed. So the current regulation that we have got is called the Asbestos Regulation 155 of 2002. And this piece of regulation, different to the older or the 87 or 89 regulation that we used to have, also includes asbestos containing materials. The difference between raw asbestos or friable asbestos and asbestos containing material is that the friable asbestos is asbestos as mined, as it comes out of a mine, where it actually carries a very high risk, so it's not bonded in anything. So the previous regulation specifically talked about the raw asbestos and handling and controlling workers' exposure to the friable or the raw or the high-risk materials. In 2002, the new asbestos regulation also includes asbestos-containing materials, which is now the roof sheeting and the fascia boards and ceiling panels and floor tiles. All these materials that contain a percentage of asbestos, which may be anything from 14% up to 54% of asbestos, depending on the manufacturer. And so the regulation calls for certain control measures for the employer and self-employed person, that he needs to control any exposure, or if he employs any people to work on asbestos, that there needs to be some controls in place to ensure that he does not inhale asbestos or he's not exposing anybody in the public to airborne asbestos fibers.
Let's just take a step back. We omitted to deal with blue asbestos. What is that, and how prevalent was that in South Africa and in South African buildings?
Blue asbestos, also called crucidolite asbestos, is the most hazardous form of asbestos that you do get. Basically because of the aerodynamic properties of the material and the extent of the chemical inertness of this asbestos material. It breaks off in very small needle-like fibers. It is very small, less than 0.2 micrometers in size. So once that it becomes airborne, it stays in air for extended periods of time because of the aerodynamic properties in its weight. It doesn't settle out. So once that you have started with asbestos work and you emitted this asbestos through your activities, it is possible that these fibers can even be blown from that specific work environment over a very far distance from your work environment. So So the blue asbestos is the fiber that is actually a straight, needle-like, very small fiber that can penetrate right through your lung into the chest lining. And mostly this is the type of asbestos that will cause mesothelioma.
Now, we're dealing in this... Sorry.
I think it's time for the lunch adjournment.
Yes. Okay.
We'll take the lunch adjournment and we'll resume at 2 o'clock. We adjourn.